national government.
I call David Clendon.
Thank you, Mr Speaker, and I rise once more with feeling, second time in an hour or so, to express support for this legislation, albeit, dare we say it, begrudging support. All of us would rather not be here debating this particular retrospective fix-it for a failed process, and it's unfortunate that we are here once again, and we hope it is for the last time in this context. So we're here. The bill, of course, is the Constables' Oath Validation Bill, and I think it's worthwhile just to reflect for a moment on the nature of that oath, which our police officers take as the last step towards becoming fully fledged constables, and before they step into the role and actually start exercising those powers and duties of a police officer. And I won't read it directly, that would seem wrong, because I think people earn the right to recite this oath, so I'll paraphrase slightly. But essentially it says that the constables, the recruits, the officers coming into the role of constable, swear to faithfully and diligently serve effectively the sovereign, the Crown, because of course the police force ultimately are answerable not to government of the day, but to the Crown, to the head of state, not to the head of government, and that's entirely as it should be, and I think it's worth recalling that. So they go on to say that they will serve without favour or affection, malice or ill will, and while constables will, to the best of their power, keep the peace, prevent offences against the peace, and to the best of their skill and knowledge, perform all the duties of the office of constable according to law. So that's a very profound statement. That's a very powerful, unequivocal statement. There are no weasel words within it. It's something that is clearly a very solemn oath entered into solemnly. And it's a great shame that for these 63 officers, the integrity of that moment, that oath, has been compromised by the administrative areas that we're seeking to retrospectively put right today. Again, the point has been made that the powers of a constable are significant. They have the power to detain, the power to arrest, the power to stop vehicles, search vehicles, to search individuals in some limited situations. There are significant powers involved, the power to, or the right to use reasonable force, which goes beyond that which a normal citizen can do. So these are not trivial matters, these are not trivial issues, and it's important that we acknowledge that the importance, the significance of what we're doing today, and indeed the significance of the errors that have been made over several years that we're now putting right. Similarly, it's worth just reflecting on a constable and what actually is a constable. And I think the common understanding would be that it's those sturdy men and women we see out on the front line in the patrol cars on the street. But in fact, it is every police officer remains a constable, from the commissioner on down. Every officer is a constable. So we're talking about the entire police force. They never relinquish those powers and duties and responsibilities while they're serving. A constable, as it says in the legislation, an employee who holds that office appointed under whichever act, and includes a constable who holds any level of position within the New Zealand Police. So it's not only the, shall we say, the front line, the new recruits who are affected by this, but in fact it's every serving police officer. I think it's worth reflecting on the fact that 63 people we're talking about whose oath of whose swearing in has been effectively invalidated by the error. We can, I think, I'm speculating here, but I think we can safely assume that at least some of those 63 returning officers would have some degree of seniority, would have some rank. So not only have they been performing their own duties, but would have been directing other officers, other units to carry out duties, which again makes the problem even more severe, that effectively the orders they've been given, the instructions they have been giving to less senior officers could be invalid, and that just creates all sorts of a rat's nest that we really don't want to see untangle, and it's important that through this legislation we put it right and validate what has been done. So I think clearly in the absence of a committee stage in this bill, we haven't paid much attention to the substance of the bill, and I'd have to say that it's a model of brevity. The explanatory note is actually longer than the bill. It consists of 4 parts: a title, a commencement date. It identifies the Principal Act, and then a short paragraph which will be inserted into the Principal Act, the Policing Act of 2008, which says simply that a police employee who has administered the Constable's Oath described in Section 22 in the period of 13 October 2009 through to 13 October 2013 is to be treated of having been authorised to administer that oath. That's the bill in its entirety, and it's a very small bill, but what it does is actually important and significant, and we should take we should attend to that. So I earlier made the point that I've written to the Auditor-General seeking an inquiry from that office into how these mistakes occurred and how we can be sure that they do not occur again. I think it's worth just commenting. I'm appealing to the Auditor-General under Section 16 of the Public Audit Act, which is headed Performance Audit, and specifically that section says that the Auditor-General may at any time examine the extent to which a public entity is carrying out its activities effectively and efficiently, and clearly there has been an effectiveness deficit here. And it goes on to say the Auditor-General may also examine a public entity's compliance with its statutory requirements. And clearly that goes right to the heart of what's occurred here and back in 2009. The section goes on to talk about financial probity, lack of probity, financial prudence. Clearly there's not the least suggestion that the police have in any way transgressed against those sections of this section of the Public Audit Act. It's very much about the effectiveness, the efficiency and the compliance with statutory obligation. And under those particular provisions, I am writing and appealing to the Auditor-General to pick up this inquiry. And so it may well be, the expectation is clearly that the responsibility for these areas will be seen to lie with the senior administration of the police force. But clearly it is also possible that some responsibility may be found to rest with the Minister or indeed with this Parliament. Each of us as parliamentarians may need to bear some responsibility. And that's fine, that's as it may be. And if that was the finding of the inquiry, then so be it. The point is it's not a witch hunt, it's not seeking simply to assign blame for its own sake. It is actually to ensure that we do understand clearly there was a process failure here on at least 2 occasions. Serious failures of process, serious failures to fulfil what would on the face of it seem to be quite straightforward obligations to make sure that this was got right. It hasn't been got right. So the intention of an inquiry must be to uncover how this happened and to be as sure as we can possibly be that this does not occur again. So, sir, with those words, I will end my commentary and to say again, we support this legislation. Nobody's happy about it, but it would be simply untenable not to see this change go through, to see this retrospective legislation go through. Thank you, Mr. Speaker.
I call in